I introduced Judge Montgomery this morning from Kingsport, but we've had a change in the panel for this last case. To my left is Judge D. Kelly Thomas Jr., who currently is serving the state as senior judge, but who for a long period of time was a full-fledged member of this court. And so I personally am glad to have him back on a panel with us today.
Glad to be here, thank you.
Call our last case, please.
State of Tennessee versus Trevor, Cullom.
Good afternoon, Your Honors.
Good afternoon.
My name is Dylan Zinzer. I'm the counsel for the appellant, Mr. Cullom, of the Knox County Bar, and I would respectfully request to reserve 5 minutes of time for rebuttal. Your Honors, this case comes before this court on two separate matters that were consolidated for the purposes of appeal. There were two docket numbers in the Knox County Criminal Court, one being docket number 122303 and the other being docket number 117642. In 122303, the appellant pled guilty and received an 8-year sentence. In 117642, there was a violation of probation. Both of these matters were consolidated in the trial court for a single sentencing hearing on June 23rd of 2023. Regarding the respective cases, on the guilty plea, Mr. Cullom was sentenced to serve that sentence on DRC, and on the violation of probation in 117642, Mr. Cullom was revoked to serve that sentence in TDOC custody. For the purposes of appeal, we are only challenging the court's ruling as it relates to the violation of probation in 117642. And specifically, Your Honors, the issue that we are raising before this court is whether the trial court engaged in sufficient analysis during that sentencing hearing to sentence Mr. Cullom to the Tennessee Department of Corrections in docket number 117642. Mr. Cullom, during the sentencing hearing, or even prior to the sentencing hearing, I believe, he stipulated that he was in material violation of probation. And he, of course, entered guilty pleas in the companion case for which he was sentenced to DRC. So the issue is not whether there was an adequate basis to violate his probation. The issue before this court relates solely to whether the trial court judge engaged in sufficient analysis to warrant Mr. Cullom being revoked to serve that sentence in TDOC custody. During the June 23rd, 2023 sentencing hearing, the state presented proof in the form of Mr. Cullom's driving history. There were 3 orders amending the initial violation of probation, the original violation of probation warrant, the DRC report for the Day Reporting Center. That DRC report recommended that Mr. Cullom enter and complete DRC contingent upon him being placed in a halfway house. And lastly, the state introduced Mr. Cullom's pre-sentence investigation report. The defense presented argument on behalf of Mr. Cullom, and Mr. Cullom allocuted as well during that sentencing hearing. The court, after the state presented their proof and the defense presented their argument in Mr. Cullom's allocution, the trial court engaged in its ruling, and that's really the heart of what is at this appeal, Your Honors. The trial court commenced its ruling by indicating that it was acquainted with Mr. Cullom. The trial court indicated that it had become acquainted with Mr. Cullom back in 2014, and the court proceeds to say that it has seen something redeemable in Mr. Cullom during Mr. Cullom's history with the trial court. The trial court specifically indicates that it is struggling with its decision because it has seen something redeemable in Mr. Cullom during the time that Mr. Cullom has been in the court. The court then addresses some issues that came up during the prior revocations with Mr. Cullom regarding some substances that were tested that turned out to be a controlled substance. And then the trial court moves into a prior matter that it involved Mr. Cullom, where the trial court states in the record that Mr. Cullom had a prior case where he was mistakenly released from TDOC custody. Specifically, the trial court says there was a case that Mr. Cullom brought before this honorable court where a decision was reversed because Mr. Cullom was not allowed to testify during a prior revocation hearing. That case resulted in a reversal, and then the trial court indicates that Mr. Cullom, after that reversal occurred, was released from custody. The court characterizes it as a mistake. The court says that Mr. Cullom should not have been released early, but that he was in fact released early, and that no one said anything about it. So in effect, the trial court is saying that Mr. Cullom received a break when he was released early from TDOC custody. The court then addresses Mr. Cullom's, I'm sorry, Justice Wood, do you have a question? I'm sorry, it just looked like you were about to speak. The trial court then talks some about Mr. Cullom's prior history, and then the trial court again continues talking about this mix-up in the trial court's estimation that it occurred with TDOC letting Mr. Cullom out early. Notably, Your Honors, that matter was not raised in the state's proof, and it wasn't raised by the defense. It wasn't present in the PSI report or the DRC report. This appears that it was an instance that the trial court was bringing its independent knowledge and experience and assessment into its characterization of Mr. Cullom being released mistakenly from the Tennessee Department of Corrections early on that previous case. And that's really the heart of this issue, is that the court does engage in some analysis, but the question is whether that analysis was sufficient in order to find that Mr. Cullom was not amenable to alternative forms of sentencing short of a full revocation in the Tennessee Department of Corrections. And we have points in the record that we can look to that show that Mr. Cullom perhaps was amenable to correction. We know that the Day Reporting Center accepted Mr. Cullom. The trial court itself recognizes that, sees something redeemable in Mr. Cullom, but the trial court, we respectfully submit, it didn't engage in sufficient analysis in order to make the appropriate findings on the record to determine that Mr. Cullom, in fact, was not a suitable candidate for alternative sentencing.
I noticed that in your brief, and you can correct me if I'm wrong, but it appears that the law that you cited as to all deals with sentencing as opposed to a revocation of probation. Am I right about that?
Yes, Your Honor, and in full candor to the court, that was an undertaking in my research that I didn't fully realize was perhaps misplaced until I read the state's response brief and read over Dagnan. And so Dagnan, of course, is really the controlling case here.
Would you agree with me that there is a marked difference in the analysis and thinking of a trial court when announcing the initial sentence as opposed to the analysis and the description of that analysis that the trial court has to do in a probation revocation?
Yes, Justice Thomas, I would agree that is certainly a different calculus. There is different case law and there's different standards that guide this court.
So how does what Judge Green said in this case measure up to what the Dagnan case says he's supposed to do in a revocation? Which is, I think that's where you were going anyway.
Yes, Justice Thomas. And the Dagnan case says that a trial court, in giving its ruling for revoking an individual to the Tennessee Department of Corrections, a trial court's analysis, it doesn't have to be particularly lengthy or detailed. It only has to be sufficient for the appellate court to conduct meaningful review. And the court does cite some factors, and we would acknowledge that this is an abuse of discretion standard that's before the court. Dagnan says that the Court of Appeals would only review this on a de novo standard if there were not any findings made at all. We acknowledge that there were findings here, but our position is that the findings were not sufficiently detailed to create a sufficient appellant record. And what's especially problematic for the appellant, Your Honors, is the fact that so much time is spent being focused on this previous case that Mr. Cullom had, where the court characterizes that he was released from TDOC early. In their reply brief, the state indicates that that's a testament to the trial court's analysis, that the trial court was thoughtfully thinking through these things, and that the fact that Mr. Cullom was released early, it was something that the trial court considered because he had been given leniency in the past, and then he was before the court on additional matters. But the problem with the analysis not being adequately developed is that we're really left to guess what the trial court meant in raising that one specific issue as well as the other issues. We may know that the court considered certain things, but we don't know the manner in which they were considered, and we don't know the manner and the amount of weight that was given to them. If the court does not have any questions at this time, I will yield the podium pending rebuttal.
Good afternoon, Your Honors. May it please the court, Brooke Huppenthal on behalf of the state. As my friend on the other side mentioned, the only claim on appeal here is that the trial court, or whether the trial court had properly placed the defendant's sentence into effect. And as Your Honor mentioned, the defendant does not cite in his brief Dagnan. He does not analyze his case under Dagnan and the two-part test that the Tennessee Supreme Court laid out, and for that reason, he has not met his burden on appeal. Here, the trial court acted within its discretion, and the proof supports the trial court's findings. Very briefly reciting through the procedural history, the defendant had pleaded guilty to attempted unlawful possession of a weapon. The trial court sentenced him to 10 years split confinement. While he was on release serving that sentence, he pleaded guilty to an additional 2 offenses. He had possessed methamphetamine and gabapentin with the intent to sell, deliver, or manufacture those substances. Following a hearing, the trial court found that he had violated his probation and placed his sentence into effect. And the trial court complied with Dagnan, which requires more than a finding that there's sufficient evidence of the violation itself, but that a meaningful review occurred. And here, the trial court did just that. The trial court had evaluated his previous probation violations, which in part, in terms of the discussion of that separate case, it wasn't that lengthy. It was approximately, I believe, a paragraph in the trial court's findings, or within the transcript itself. And the context in which the trial court had framed discussion of that case was in the defendant's continued and demonstrated behavior of violating his probation. And the trial court similarly discussed the defendant's failure to reform his behavior. The proof supports each of those findings. On the risk and needs assessment, the defendant scored high for violence. He had an extensive criminal history, included several misdemeanors, 6 felonies, which did include some violent felonies. He had 70 disciplinary infractions while serving in TDOC custody. Those infractions included possessing deadly weapons and pharmaceuticals, sexual misconduct and harassment, assaults, and the list goes on. He also had a 3-decade history of substance abuse, but the strongest evidence in support of the denial is the fact that he has already received alternative sentencing on several occasions, and he continues to demonstrate a history of violating while on release. For that reason, the evidence shows that the trial court did act within its discretion upon placing his sentence into effect. And unless this court has any further questions, the state asks that this court affirm the trial court's judgments. Thank you.
Thank you, Your Honors. To address the state's points, part of the difficulty that we're faced with due to the trial court's review is the fact that there was various proof that was put on by the state, and of course the defense made its arguments and Mr. Cullom presented his allocution, but without the state formally going on the record, or without the trial court making these specific findings on the record, we don't know what was accredited, we don't know what weight was assigned by the trial court judge. We're left in a position where we look at the entire record and we look at the analysis that the trial court did engage in, and then we're left to guess what was it that really convinced the trial court to move one way or another, in light of the fact that the trial court still found that Mr. Cullom was given DRC on his guilty plea case. Through the DRC report, we know that he was accepted into DRC. We're really just left to wonder, and we have no idea how much weight the court applied to the fact that Mr. Cullom was, in the court's opinion, released from TDOC early. And I of course don't want to be repetitive to Your Honors, but that's just something that wasn't in the record, and we would submit even under Dagnan, that's not something that the court should have considered. The court, of course, could consider it if the court constructed it in a way to determine that he had been given Mr. Cullom had been given leniency at one point in the past, but the court doesn't frame it that way. We as attorneys, we have to stand back and look and think, well, maybe that's what the court meant, and maybe that's what's not, and that goes against what Dagnan prescribes, even though it doesn't have to be an extensive reasoning, it doesn't have to be extremely in-depth. There still has to be enough on the record for appellate review to be adequately conducted. We would ask that the court reverse the revocation on Mr. Cullom's case and that it be remanded to the trial court for a new sentencing hearing with the assurance that the proper factors will be weighed to create an adequate record. Thank you, Your Honors.
All right, thank you. Court thanks you both for your argument today. And if there's nothing else before the court, the court will be adjourned until the opening of the July term.